The meeting is called to order. Good afternoon. I'm the chair of the United States Sentencing Commission, Carlton W. Reeves, and I welcome you all to this meeting. I thank each of you for joining us today, whether you're in this room with us or attending via live stream. I have the honor of being here today with my fellow commissioners, your public servants. To my left, we have Vice Chair Claire Murray. To her left, Vice Chair Laura Mate and ex officio Scott Meisler. To my right, we have Vice Chair Louis Felipe Restrepo and Commissioner Candace Wong. We're also joined by Commission employees, some of whom, again, are in this room, most of whom are not. They are doing the work of the business of this commission. They've done the research that we'll be talking about today. They've drafted the priorities. They've set up this room on behalf of the commissioners and the public. We thank all of our agency staff for the amazing work that you do every single day. The first order of business is a vote to adopt the April 11th, 2025 public meeting minutes. Is there a motion to do so? Is there a second?
Second.
Is there any discussion on this motion? Hearing no further discussion, vote for the motion by saying aye. Aye. Any nays? No nays. The motion is adopted by voice vote. The next item of business is the report of the chair. Today, ladies and gentlemen, we will be holding a series of votes involving the final priorities for the coming amendment cycle and retroactivity regarding our last amendment cycle. We will conclude with some remarks from myself and my colleagues. So the next item of business is a vote on the final policy priorities for the 2025-2026 amendment cycle. The General Counsel, Ms. Greeley, will now advise the Commission on that matter.
You have before you a notice of final priorities for consideration. You published a notice of possible policy priorities in the Federal Register on June 11th, 2025, and the Commission received and reviewed public comment pursuant to that notice and made changes to the tentative priorities. A motion to adopt and publish in the Federal Register the final notice of policy priorities for the Commission's 2025-2026 amendment cycle would be in order at this time.
Is there a motion to adopt and published in the Federal Register the final notice of policy priorities for the Commission's 2025-2026 amendment cycle as suggested by our General Counsel?
So moved.
Is there a second?
Second.
Is there any discussion on the motion? Hearing no further discussion, you may vote on it by saying aye. Aye. Any nays? Hearing no nays, the motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion. The next item of business is a possible vote on the retroactive application of Amendment 832 and Subpart 2 of Part A of Amendment 833. The General Counsel will now advise the Commission on that matter.
The Commission has been considering whether to add Amendment 832, which was your amendment resolving. Sorry. The Commission is considering whether to add Amendment 832, which was the amendment resolving 2 circuit conflicts, and Subpart 2 of Part A of Amendment 833, which addressed drug offenses, to the list of amendments in 1B110 that may be applied retroactively. In accordance with your Rules of Practice and Procedure, Rule 4.1A, The Commission solicited public comment on the issue, instructed staff to prepare a retroactivity impact analysis report, which was released to the public during the comment period, and held a public hearing on the issue. A motion to promulgate the proposed amendment to 1B110 with an effective date of November 1st, 2025, and technical and conforming amendment authority to staff is appropriate at this time.
The next item of business.
Go to the next page.
Okay, I'm sorry. Is there a motion? No problem. Is there a motion to promulgate the proposed amendment as suggested by our general counsel? There is no motion, so I'm not going to ask for a second. Okay, thank you.
Your next item of business at the bottom of page 4.
Okay. The next item of business is a possible vote on the retroactive application of subpart 1 of Part A of Amendment 833. The General Counsel will now advise the Commission on that matter.
The Commission is considering... Having a day.
The gremlins are out here today, that's all.
I was reminding all the witnesses yesterday. I need myself again. The Commission is considering whether to adopt whether subpart 1 of Part A of Amendment 833, which amended the mitigating roll cap, should be included in the list of amendments in 1B110 that may be applied retroactively. In accordance with Rule 4.1A of the Commission's Rules of Practice and Procedure, the Commission solicited public comment on the issue, instructed staff to prepare a retroactivity impact report, which was released to the public during the comment period, and held a public hearing on the issue. A motion to promulgate the proposed amendment to 1B110 with an effective date of November 1st, 2025, and with technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion to promulgate the proposed amendment as suggested by our General Counsel?
So moved.
Is there a second?
Second.
Is there any discussion on this motion before we take it up for a vote? There is. The Commission, ladies and gentlemen, is committed to two things above all else. In other words, I'm starting first. I'm sorry. Data and democracy. Our commitment to data means making decisions based on the best available evidence and research. And our commitment to democracy means interpreting that evidence and research through a deliberative process, one that aims to reflect the voices, the views, and the values of all the people, and what I always refer to as we the people. Sometimes our deliberations result in unanimous agreement about the single best policy, about what the single best policy is. Other times, our deliberations lead to a slate of policies that together we agree is worthwhile. Unfortunately, there are times our deliberations end in disagreements we cannot fully resolve. Today is one of those times. When it comes to retroactivity, we commissioners have a wide range of deeply held and well-reasoned views about what the right path forward is. And while we disagree on that path, we, as I said from the very first day I talked to you, we will never be disagreeable. I'm so proud to serve alongside my colleagues. Each has given their all to our deliberative process, to living out our commitments to data and democracy. To further those commitments, we will all shed some light on our individual views about retroactivity. Speaking for myself, I would have voted to make many of our recent amendments retroactive, including the one we're voting on today. I think the benefits of retroactivity often outweigh the perceived costs. And I think we tend to overlook those benefits because of how we approach the underlying data. The Commission policy statement on retroactivity says we must consider, among other factors, the, quote, difficulty of applying the amendment retroactively, close quote. When we talk about that specific factor, we often use the term administrability. And that term often ends up being shorthand for the administrative impact of retroactivity on the justice system. That impact is usually described in terms of work added to the court's dockets. Of course, that work can take a significant amount of time to complete, and that work can be annoying, it can be frustrating, and it can even feel frivolous. It can even delay other important judicial business. But it's not enough to simply recognize the cost of administrative annoyance and delay of retroactivity. Those costs need to be calculated clearly, I believe, and they must be weighed against all other administrative costs, including the costs of administering imprisonment. Today, those costs stand at $51,711 and rising for the work performed by BOP, the Bureau of Prisons, and paid for by the taxpayers. $51,711 to incarcerate a single person for a year. For the amendment we are discussing today, the relief of retroactivity to the Bureau of Prisons and taxpayers easily runs in the many millions of dollars. I believe that a full consideration of all the administrative costs standing on their own would weigh in favor of retroactivity. Moving forward, I believe the Commission should avoid weighing abstract claims about administrability that only discuss cost on one side of the government's financial ledger. Of course, the Commission should take less quantifiable costs and benefits into account. But even there, I think our calculus is a little off. That's because it's easier to estimate the costs we felt personally. We know the cost of doing extra lawyering. We were and have been lawyers. The cost of addressing the merits of a motion. Some of us have been judges. The cost of crime caused by recidivism. We're all citizens in this country. But there's one cost few of us have ever paid: the price of spending one day more than necessary in prison. That cost is often immense. I certainly believe that is the case for the amendment we're voting on today. Here, retroactivity would have ended hundreds of years of imprisonment. The struggle across the justice system to recognize the true cost of imprisonment is a problem. It is a problem rooted in the absence of all the people and we the people from the halls of government. It is a problem of democracy, and it is a problem the Commission is working to fix. Just months ago, the Commission created the Sentence Impact Advisory Group. It is a committee of formerly incarcerated people and their family members. Their work will be essential in helping ensure that all our decision-making, including that of retroactivity, fully accounts for the costs of incarceration. So to all of you who have been tuning into our meetings and hoping that we will make our past amendments from this last cycle retroactive, your hopes may not be realized today. But I promise, no matter who you are, whether you're someone who has suffered a loss of a loved one to a crime or suffered a loss of a loved one to incarceration, your voices have been heard, and your voices will be heard. That's my comment on this statement. This is my statement with respect to the vote we're about to give, and I turn to anyone who wishes to make a statement now. Vice Chair Mate.
Thank you, Chair Reeves. I share your gratitude for each and every one of my colleagues, commissioners, and staff, and our ability to work conscientiously and collaboratively on important issues. I also share your thoughts that many of our recent amendments would be appropriate for retroactivity, most clearly our amendment to the mitigating role cap and the drug guideline. The factors we've looked to in the past, purpose, magnitude, and the ease of applying the amendment retroactively, all support retroactive application. This amendment makes clear that when assessing appropriate punishment, an individual's role in the offense matters. It recalibrates the relative weight the guidelines recommend courts give to role and drug quantity. Our impact analysis estimates an average reduction of 12 months, a full year. That is a meaningful reduction for any person serving any length of sentence. To be sure, any retroactive amendment requires time and resources from judges, probation officers, prosecutors, and defense counsel. So I know there would be work. That work must be weighed against the liberty interests of the individuals who, if sentenced today, would have a lower guideline range. The testimony I heard last month confirmed that this amendment would pose a lower administrative burden than most. Eligibility for this amendment would generally be clear from the papers, and most districts already have processes in place to efficiently screen, file, and resolve these motions. Importantly, retroactive application of this amendment is also consistent with the Commission's duties and purposes set forth in our organic statute. For example, it would ensure similarly situated individuals, whether they were sentenced last year, today, or are sentenced after November 1st, are not treated dissimilarly and are sentenced pursuant to uniform guidelines. And Commission data on recidivism related to the retroactive application of the Drugs -2 amendment assures me that the retroactive application of this mitigating role cap would not undermine public safety. The Commission was designed to create guidelines that evolve over time, to regularly amend these guidelines based on new information, research, and data, and to make those amendments retroactive when appropriate. Last, I want to briefly express my concerns about fundamental fairness as a limiting principle. What appears to have started as a justification in support of retroactive application of our crack cocaine amendments has sometimes been treated as a prerequisite to retroactive application of guideline amendments. Congress has never required, and the Commission has never adopted, a threshold requirement for retroactivity that the purpose of an amendment be to address an issue of fundamental fairness. Nor has either Congress or the Commission defined what fundamental fairness might mean in this context. To be sure, fundamental fairness may weigh in favor of retroactivity, as it did with crack. But to limit retroactive amendments to only those with the purpose of addressing an issue of fundamental fairness, however that term is defined, would be inconsistent with past practice, as well as our statutory purposes and duties. To deny someone sentenced yesterday with the benefit afforded someone sentenced today is always unfair. And I worry that the discussions of fundamental fairness obscure our need to grapple with that fact when making decisions about retroactivity.
V.C. Restrepo.
Thank you, Chair Reeves. I favor retroactivity as a general principle, and I join the views expressed by Chair Reeves and Vice Chair Mate, as well as their gratitude for the thoughtful work of my fellow commissioners and the staff at the United States Sentencing Commission. I would vote in favor of retroactivity for the mitigating role cap, which in my view fully satisfies the Commission's established criteria for retroactive application. It advances the purposes of sentencing articulated in Title 18, Section 3553A, produces meaningful impacts for a broad group of defendants and presents a limited administrative burden. Eligible defendants serving time above the amended mitigated roll cap are serving sentences the Commission no longer considers proportionate. Sentencing is not a stagnant exercise, and retroactivity is a recognition that the guidelines can and should evolve, consistent with data supporting amendments to the guidelines. Whenever we amend the guidelines to correct unwarranted severity, to reduce disparities, or to better align with the statutory purposes of sentencing, we implicitly acknowledge that our previous analysis is no longer supported by the data. The date a sentence was imposed should not dictate the length of that sentence, nor should it reinforce disparities between two similarly situated defendants. To leave earlier sentences intact is to make timing rather than culpability the decisive factor. Instead, we should continue to promote uniformity, consistency, and fairness, core parts of our mission as a commission. A sentence we would not impose tomorrow is one we should not preserve today. Thank you very much.
Thank you. Commissioner Wong.
Thank you, Chair, and thank you to my colleagues for your statements. The subpart of an amendment we are debating is a fine-tuning of the offense level caps applicable to certain high-quantity drug traffickers whom a court nonetheless has found to have played a mitigating role in the context of their offenses. Vice Chair Murray and I agreed to support these adjustments as part of our package to Congress, part of our continued efforts to making each year's guidelines manual an improvement on the last. But we also do not believe these adjustments merit reopening long-closed, otherwise final criminal cases. And we take seriously the concerns forcefully expressed by the Criminal Law Committee of the United States Judicial Conference, the Probation Officers Advisory Group, and the Victims Advisory Group, as well as the U.S. Department of Justice, all of whom opposed retroactive application here. The Commission's own rules of practice and procedures state unequivocally that generally, promulgated amendments will be given prospective application only. That principle inheres in the very fabric of our justice system. Finality is essential to our system of determinate, predictable sentencing. Finality undergirds public trust in our justice system. It safeguards the rights of victims, including victims of drug trafficking offenses. And conversely, frequent retroactive application of amendments to reopen and often reduce sentences will erode deterrence and strain the finite resources of our judges and probation officers. For these reasons, the Commission has always treated retroactivity as the rare exception, not the rule. Our mitigating roll cap adjustments are not the rare exception to the rule. When we examine their purpose, the magnitude of change they affect, and the difficulties of retroactive application, the balance of considerations does not overcome that presumption against retroactivity. First, purpose. As stated, the purpose of the mitigating roll cap adjustments was to refine. In a presumptive prospective regime, it is clear that mere guideline differences pre- and post-amendment do not themselves justify retroactivity. Rather, retroactivity has been reserved for measures regarded by the requisite Commission majority as sounding in fundamental fairness. As then Commissioner, now Judge Howell, explained in 2010, deeming the Commission's elimination of recency points inappropriate for retroactive treatment, that amendment's purpose was not to correct a perceived fundamental unfairness. Then Commissioner, now Justice Jackson, echoed her emphasis on fairness-type concerns. Here, our work fine-tuning the mitigating roll caps was intended to hew more closely to sentencing data on the ground, which showed frequent variances by judges in sentencing this slice of defendants on account of their mitigating roles. This was not redress of fundamental injustice, albeit a worthy refinement of our guidelines to promote greater guidelines utility and consistency in sentencing. Next, magnitude of change. Here we are told that a relatively modest number, 650 defendants, could be eligible for reductions, and by relatively modest levels. About 95% would see lower base offense levels by merely 1 or 2 levels, with over 60% receiving a reduction of 1 year or less. And any assessment of the magnitude of change must further factor in our driving consideration that judges were already taking seriously and carefully factoring in the mitigating roles played by this slice of defendants, even pre-amendment. Finally, the difficulties of application. Even for the 650 eligible defendants, the difficulties should not be understated. It may be challenging for judges to reconstruct and disentangle the extent to which the then existing caps anchored, if at all, their original sentence in a manner not already accounted for. And administrability, of course, does not simply come down to the 650 or so eligible defendants. It is about balancing the potential benefits and burdens on the justice system to be yielded from the many multiples of that figure who will seek relief through motions that will inevitably, as they should, command extraordinary and prompt attention and care by judges and probation officers. That far larger universe is particularly difficult to quantify here, where discerning who is and is not eligible is no straightforward matter, where the caps in question are found in a multi-tiered provision, which itself is triggered by a separately defined mitigating role adjustment, which itself has seen its parameters just amended by the same commission, and yet whose amended parameters are not being made retroactive. Under these circumstances, it is the view of Vice Chair Murray and I that retroactive application would be inconsistent with the presumption against retroactivity, the Commission's practice and precedents, and the weight of commentary from our stakeholders.
Thank you. Thank you, Commissioner Wong. Vice Chair Murray.
Thank you, Chair. Last but not least, I appreciate the opportunity to explain my vote to the public and to all of you. I wanted to start by saying that I'm so thankful for you and for all of our colleagues. It is an honor to serve on a body that takes so seriously our weighty responsibility to advance the cause of justice and to keep always in mind the sort of important impact that all of our actions can have on our fellow citizens, both in and out of prison. I do agree with Commissioner Wong, and I will be voting against retroactive application of this amendment. And the reason I'm voting in that way is maybe threefold. So first, as Commissioner Wong said, under our rules of practice and procedure, there is a presumption against applying our amendments retroactively. To my mind, that presumption is not overcome here. When I voted for this amendment, I saw it as a refinement of the existing regime that was made to track sentencing trends, not as a fundamental change. And I think our precedents provide some support for that view. In 2002, the Commission first amended the guidelines to establish the mitigating role cap. That was, I think, a more fundamental change than this amendment, which merely tweaks the existing cap. But the Commission nonetheless chose not to make that amendment retroactive. I am unable to come up with a reason why this amendment would overcome the presumption if that one did not. Second, I'm persuaded by the testimony of our Article 3 stakeholders in particular. So by that I mean the Criminal Law Committee of the Judicial Conference, which represents the judges, and our Probation Officers Advisory Group, both of whom have a history of supporting retroactivity in other contexts. Both the CLC and POAG have asked us not to make this amendment retroactive. They have pointed to the significant number of motions filed by ineligible defendants when we made our status and 0-point amendments retroactive. The numbers on that, I think, are striking. Fully 78% of 0-point applicants and 70% of status point applicants were completely ineligible under the retroactive amendment, even before application of the 3553A factors. Over the past 2 years, we've heard from many judges, probation officers, and prosecutors, both formally and informally, that those motions consumed scarce resources and crowded out other vital functions that keep our communities safe and support the administration of justice. That's not to say that they didn't have benefit, of course, but there's also a cost to those motions, a more than monetary cost in some cases. Finally, I'm persuaded by the comments of judges who asked us not to make amendments retroactive, where they, quote, address matters that I would routinely consider anyway. To my mind, this is an example of that kind of amendment. Some of our past amendments implemented surprising or counterintuitive research that a judge wouldn't have been able to know about and take into account at a defendant's initial sentencing. Our status of points amendment, I think you could say, was such an amendment. We largely eliminated the status point enhancement because of new research showing that committing a crime while on probation or supervision does not correlate with a higher risk of recidivism. That research was sufficiently counterintuitive, at least to me, that before it emerged, Judges could not have been expected to take it into account when sentencing defendants whose guidelines calculations incorporated status points. This amendment, I think, is the opposite. A defendant's role in the offense is something every judge already considers when applying the 3553A factors in every case necessarily. To quote one of our recent judicial commenters, I gave the sentence that I thought was fair and just, based on the facts and circumstances of the offense and the personal characteristics of the defendant, and considering the 3553A factors. The retroactive change leads to very little relief to the offender and creates tremendous work for the probation offices and the courts. For that reason, I agree with the CLC that, quote, the data shows that judges are already addressing, at least in part, any perceived unfairness issues by varying downward as appropriate in individual cases. I don't mean to perseverate on this, but I've been thinking about this particular point quite a bit. We already know, with respect to this particular amendment, that 60% of those whose base offense levels would be changed by this amendment are ineligible for relief because under the new amendment, because their original sentence already fell below what their new amended guidelines range would be. Those people are already not included in our retroactivity impact analysis. But even of the remaining 650 defendants who could potentially be impacted by retroactive application of this amendment, if we were to make it retroactive, so these are people that our retroactivity impact analysis assumes may receive relief. An additional 52%, that's 337 out of 650, had already received a smaller variance at sentencing, at their initial sentencing, such that their initial sentence was already within their what would be their new amended guidelines range. We don't for sure know why that happened, but I think it's very likely that at least in some cases that was because their original sentencing judge took into account their minor or minimal role and varied downwards. And at any rate, it does limit the amount of a further adjustment that they would be eligible for. This is not a decision I took lightly. I spent a lot of time thinking about it. I appreciate the process that our commission went through, but for those reasons, I'm convinced that a faithful application of our precedents and of the principles guiding our retroactivity decisions militate against retroactivity in this case. Thank you.
Thank you, Vice Chair Murray. Is there any further discussion on the motion? Hearing no further discussion, let's vote on the motion by saying aye. Aye. Any nays?
Nay.
The motion fails. Let the record reflect that fewer than 4 commissioners voted in favor of the motion. Is there any further business before the commission? There probably is not, but I will tell you, to keep up with the work that our staff does every day, I'm asking the public and I'm asking the practitioners and the stakeholders and everyone, I'm asking you to keep up with www.ussc.gov. There is a treasure trove of information there. Those are my closing remarks. No more further business before the commission. I've heard none. So is there a motion to adjourn?
So moved.
Is there a second? All in favor, say aye.
Aye.
Hearing no nays, we are now adjourned. Thank you.